trial has been a long time in the making. In fact, the matter has been a long time in the making, but the trial itself actually began in April. But the former president has, of course, spent months trying to get Downer to be recused from this particular case. Let's get you some analysis now. Bring in Elton Hart, who's with the University of Johannesburg's Law Clinic. He joins us now via our video link. And Elton, it's great to have you on the program. Thanks very much indeed for making time. The application itself, in its current form, has been dismissed before. That in mind, to what extent do you reckon today's outcome is a far-gone conclusion?
No, I won't say it's a far-gone conclusion. I think most probably, of course, what the former president is asking the court to say, listen, yeah, give me an opportunity to go to a higher court to actually ask them to look at the facts again and say, is there most probably merits in my application for Advocate Billy Downer to step down in this matter? So that is essentially what the court needs to make judgment on today. And I think Judge Kuhn, most probably he will say, okay, let me err on the safe side and rather say, I will allow you to go to the Supreme Court of Appeal, and maybe they will then just vindicate me in saying that, Judge Kuhn, you were right in your decision. Or it might come back and then the former president gets a chance to actually go and try and convince the SCA judges that Advocate Billy Downer should not be the one prosecuting the case.
So no matter how it goes today, two things are certain. One, we are certain to not necessarily have a start of the trial date yet. But two, we actually don't even know if Billy Downer will be recused, because if, for instance, the former president is granted that leave to appeal, there's more arguments that need to take place at this different court.
Obviously, if one looks at it now, yes, but now the scope is a little bit narrow, because they cannot now introduce new things, because if they appeal, you appeal on the record. So whatever you said in the High Court, you'll have to bring that back in the magistrate's court, not in the magistrate, in the SCA again. So you cannot go back and change whatever you are doing now. You have to stick to what was ruled upon previously. So for me, it's like simple. You stay within that parameters. You cannot go and say, now I want to introduce new facts. You need to go and say, this is the record, and we're going to argue based on this. And obviously, if the SCA maybe rules against the former president, and I think and I know he will most probably go to the Constitutional Court as well. Further to that is that also that we should not lose sight. The trial has already started. This is just a trial within a trial. So he's going to already saying, I'm not delaying the trial. The trial has started. I'm just raising interlocutory issues here that I feel that I need to first establish before I can actually proceed with my trial, because I want a fair trial.
Sure. You know, part of what the NPA has said in this protracted back and forth is that even if Downer is removed from this case or recused from this case, it won't stop the trial itself from continuing. But it does introduce quite the spanner in the works, doesn't it, when you consider just how involved Downer has been in this matter, which, again, is years in the making.
Yes, definitely. Advocate Billy Downer was with this case, I think it's for the better 16 years now. But I think the NPA can eliminate a lot of these issues by actually just getting one of its other competent advocates to actually step in. And I know there were some people that was working with Advocate Billy Downer on this matter as second and third chairs in the investigation and in probing these corruption charges against the former president. So if the NPA was clever, they should have, when they saw that the former president is starting with these, that Advocate Billy Downer lacks title to prosecute, they were supposed to dedicate a prosecutor and say, for the next year, you just study this docket. So if it comes at the court, be it the SCA or the Constitutional Court at a later stage, maybe say, Advocate Billy Downer, you have unduly influenced the investigation, you've meddled with witnesses, you cannot prosecute. Then they say, okay, no problem, Advocate Ayanda will take over the matter. Something like that. The NPA should have that in the pipeline. If they didn't do it, then it means it's sloppy work by the NPA. And I would think they were supposed to go straight up from the onset and say, okay, if you're making a big fuss out of Advocate Billy Downer handling the matter, then we will just bring on another advocate, and then you can't come and say there's bias or prejudice, or you won't get a fair trial in terms of Section 34 and 35 of the Constitution.
I'll tell you what, Advocate Ayanda is best suited staying far away from this trial. But what was also said, you know, you've mentioned that we're kind of anticipating a narrowing of the scope, even if the former president is granted this leave to appeal. Does that mean that the request made by the former president's legal team for the entire NPA to be, I guess, questioning the integrity of the entire NPA is now by the wayside? Is that a argument, a discussion that's no longer taking place?
No, they cannot, because with appeal proceedings, one needs to always know. When you appeal against a judgment from a lower court, and a higher court won't necessarily interfere with the judgment of a lower court to such an extent that they would now sort of like nearly re-hear the matter. They will go and say, on the record, what was your arguments that you advanced? Because you're just saying to the higher court that I think given the same set of facts that's in front of the high court, you as a higher court will come to a different conclusion hearing the very same evidence. So that's why I'm saying the scope is narrow. So the former president will have to go and advance these very same reasons, which is already captured in the record, the appeal record, and take it to the SCA when they petition to the, or when, if they get leave to appeal, or if they have to petition to the SPA and say, SCA to say, this is the only facts that we're going to place before you. They cannot come and introduce new things now and say, okay, Advocate Billy Downer did this now, the NPA did this additionally after our first initial hearing. They have to stick to the record. So there is already, their hands are in shackles, so they can just stick to that record there.
Critical clarity that you're providing this morning. Thanks very much indeed for your time. Really do appreciate your take on this matter. Elton Hart is a legal analyst with the University of Johannesburg's Law Clinic.